NBC, Fox, and the BBC. Professor Blackman is also a frequent guest on NPR and other syndicated radio programs. He has published commentaries in the New York Times, Wall Street Journal, Washington Post, and other leading national publications. Since 2012, Professor Blackman has served as a professor at the South Texas College of Law in Houston. He holds the Centennial Chair of Constitutional Law. Professor Blackman is the senior editor of the Heritage Guide to the Constitution. He has also written more than 7 dozen law review articles that have been cited more than 1,000 times. Professor Blackman was selected as the Jurist of the Year by the Texas Journal of Law and Public Policy. He received the inaugural Mies III? Is that what it is?
Yeah.
Originalism Award from the Heritage Foundation, and he was awarded the inaugural Joseph Story Award. He's also been selected by...
That's enough. Go on.
Okay.
That's enough. That's enough. I got it.
Y'all both have very, very long and impressive ones, so
yeah.
okay, I'll condense. So there you go. Professor
I'm Josh. That's good.
Okay, for Professor Samuel Markison, he has been a member of the Brandeis School of Law faculty since 1996. His teaching and scholarship focus on constitutional law, employment discrimination, and the civil rights of LGBTQ+ individuals. After graduating from Yale Law School in 1986, Professor Markison clerked for Judge George C. Pratt on the U.S. Court of Appeals for the Second Circuit. He then joined the appellate staff of the Equal Employment Opportunity Commission in Washington, D.C., where for 8 years he briefed and argued cases in the Federal Court of Appeals. While at the EEOC, he also helped design and conduct the agency's training program following the enactment of the Americans with Disabilities Act in 1992. Professor Markison is the author of Original Sin, Clarence Thomas and the Failure of the Constitutional Conservatives, a critical examination of constitutional originalism and judicial consistency. His articles and commentary explore the 14th Amendment, equal protection, and evolving civil rights issues. He has served on the board of directors of the National Lesbian and Gay Legal Association, coordinated programming for its annual conference, and served on the coordinating committee of Louisville's Fairness Campaign. Since 2013, he has been a member of the Kentucky State Advisory Committee for the U.S. Commission on Civil Rights. And to me, this is the most important. He continues to be a respected teacher and mentor to students, bringing his deep experience in civil rights litigation and constitutional law to the classroom. Please help me welcome our esteemed guest.
Thank you. Thank you so much, Louisville. I guess I brought the rain. I'm sorry. Although we have a drought in Texas, so please don't blame me. Oh, we're from Texas.
Love HEB.
HEB is the best. I love Louisville. I clerked for Judge Boggs years ago. It's a city I always love to visit. Thank you to the dean for being such a kind host, Professor Markison as well. Let's do some numbers first. So just show of hands. How many cases of the court last year were either unanimous or 8-1? Said, who thinks 10%, 20%, 30, 40, 50? The answer is half. Yeah. Last year, believe it, it's true. Last year, about half of the cases were the unanimous or 8-1. So it's not perhaps as divided as you might think it is. Okay. What percentage of the cases were 6-3 with only Democrat appointees in dissent? About 10%. Oh. How many cases were there which had 3 or 4 Republican appointees in dissent? About 10. Huh. So the court, to be sure, is conservative. There's no doubt about this. This is not the court that existed in 1996 when Professor Markison started teaching, or perhaps in the 80s when he was going through law school and practicing. This is a different court from years ago, but it's not this monolithic court that you might think of. Now, who's in the majority the most? It's Chief Justice Roberts, about 95% of the cases. But believe it or not, who's in the majority more? Justice Kagan or Justice Thomas? The answer is Justice Kagan. Justice Kagan was in the majority more than 80% of the time. Thomas the majority about 70% of the time. So the court, again, to be sure, is conservative, but not always. In fact, the 3 cases that he picked were all authored by members of the progressive wing, and they were majority opinions of some significance. Okay? Now, which circuits get the most reversals? Now, you might think, oh, it's the Fifth Circuit. And that's actually not entirely accurate. The Fifth Circuit had a reversal rate of 77%, which is, not great. But the Fourth Circuit went 0-8. 100% reversal rate for the Fourth Circuit. Sixth Circuit did pretty well, actually. It's towards the middle of the pack, so go for the Sixth Circuit. Okay. So the overview of the court, though, is the merits docket. Much of what the court does, though, is not on the merits docket. It's what's called the emergency docket, or the interim orders docket, or, if you will, the shadow docket, which I don't like.
I love it.
Oh, he loves it. It sounds dark and sinewy. Everything's open. We know what's going on. There are opinions that are written. What we don't know is the reasoning. So in the last, 8 or 9 months since President Trump came to office, there have been a slew of cases on the emergency docket. They've involved the president's power over removal. They've involved the power to remove civil servants in various departments. They've involved the power to cut funding as part of the DOGE implementation. There are now powers of firing people. Can they fire members of the Federal Trade Commission, fire members of the National Labor Relations Board, those other agencies? For the most part, Trump has won those cases, although there's some minor defeats along the way. But what's significant is many of those emergency docket cases will come back to the court now on the merits. So we're going to be talking about cases decided last year, but we can just mention cases coming up. Perhaps a big one involves birthright citizenship on the merits. The court will hear that this year, and we will probably get a ruling on the merits. Another big case coming up this year involves Humphrey's executor. Can Congress protect members of independent agencies from removal unless there's cause? Trump fired members of the Federal Trade Commission without any cause, saying this law is unconstitutional. We also have a case involving what's called impoundment or cutting spending. Can the president not spend certain amounts of money? So that's all from last year. Let's now take a look back, and I will start with a case that probably a lot of you heard of called United States against Scrimeti. There's a case from the Sixth Circuit. It's a Tennessee case. In recent years, there have been a number of states that have created bans on what's called gender-affirming care. This is a pretty broad category of treatment. It could include things like puberty blockers, cross-sex hormones, and in some cases, actual surgical procedures performed to change a person's anatomy. Okay. Now, the reason why this is done, as many of you know, is people say that their gender identity, how they view themselves, is not consistent with what their body is, and they take different medical treatments to get there. States have not yet at least banned this treatment for adults, that is, people over the age of 18. The laws in this case focus on minors. As the case came to the Supreme Court, they weren't really discussing the idea of surgery, that is, performing surgical operations on people to change their anatomy. Instead, they were focusing almost exclusively on puberty blockers and cross-sex hormones. Okay? So here's how the law worked. If you were below a certain age, you could not get these treatments. There were two constitutional arguments raised against this. The first is what you might call the Due Process Clause of the 14th Amendment. The argument was that parents have a right to direct the medical treatment of their children, and the parents who want their kids to have these treatments should be allowed to have them. Basically, a substantive due process challenge. The second category of challenges what might be called equal protection. The argument was like this. This is a form of sex discrimination. And how does it work? If you are a biological male and you want to take some of these drugs to remain a biological male, you can use these drugs. But if you're a biological male who wants to appear as a female, you cannot have these. So that is a form of sex classification. And under the precedent of United States against Virginia, the VMI case, the court said, we review sex classification with a heightened standard intermediate scrutiny. Okay. Sixth Circuit said these laws were valid on both equal protection and due process grounds. The Supreme Court did not grant the petition from the ACLU on the due process issue. They just didn't grant it. They only granted the government, which was the Biden administration's petition, on equal protection. So the only issue there was whether this law violates the Equal Protection Clause. This was one of the cases, but 6-3 along the predictable sort of ideological lines. The Chief Justice wrote the majority, and you have a dissent by Justice Sotomayor, joined by Justice Kagan and Justice Jackson. The majority opinion by Chief Justice Roberts, I describe as an act of magic. It's misdirection. He says, don't look here, look over there. The puppy's in the age room. Look at the puppy, don't look here, right? That's how the chief works. He's a magician. He's like Houdini. So Roberts goes like this. He's actually very clever, which is the problem. He's too clever by a half. And maybe Professor Marcus agrees with me on this. He says, look, this is not sex discrimination. It's age discrimination. Wait, what? If you're 18 years old, you can get this treatment. If you're under the age of 18, you can't. So that's just age. For example, what's the age to get a driver's license in Kentucky now? Is it 16? In some states it's 17, some states it's 18, right? Some states it's 15 for a permit. Generally, the government can separate people based on age. It's considered non-suspect classification and a rational basis review. So Rob says, look, this is just discrimination on the basis of age. But I think that argument is not great because you only take puberty blockers when you're going through puberty. And when you're 18, you don't usually, well, maybe some people do, but you're not on puberty anymore. So Roberts kind of looked away. The other thing he said was, well, this is not really sex discrimination because it's just saying you can use a medicine for one purpose but not another. In other words, you can use a puberty blocker to remain in your sex but not to change your sex. It's a somewhat unsatisfying answer, but the court upheld it. You have concurrences by Justice Thomas and Justice Barrett to say, no. Transgender status is not some sort of suspect classification. This law survives. And Justice Alito more or less hinted that, yes, this is sex discrimination and it's okay. It satisfies review. The dissent by Justice Sotomayor said this is the longest line in discrimination against sort of vulnerable people. The court doesn't really address the core issue. This will come back to the court, though, this term in the case involving female athletics, right? Can transgender athletes participate in female sports? It'll be harder to duck the sex discrimination issue there, but the court will probably find a way.
Just a couple of things about Scrimetti before I move on to the next case. The first thing is, to me, what was most troubling in the court's handling of the case was that they ducked the substantive due process issue because by not taking the petition on that question. Because this is a court, as we'll talk about in the case I'm going to talk about next, that has shown enormous solicitude for the rights of parents to direct the upbringing of their kids. We'll talk about that in the school context. And yet in this case, where to me that's the most powerful argument, although I also agree with equal protection dissenters, the issue of the parents' ability to not have government interfere with the choices they make in the best interest of their child, the only way in my mind that you can get around that is to take the position that for a parent to decide to, with the consultation with their doctors, to have this treatment for their child is that somehow constitutes child abuse. That the legislature decides, you know what, that's so outside the pale of what a parent can decide is best for their child, that we're going to take away that autonomy, and we do that in situations, for example, of child abuse. And the idea that the Tennessee or other legislatures can interfere with a parent's ability to make those decisions, that somehow the legislators of Tennessee or Kentucky have greater insight and knowledge into what's best for a child that a parent gets to decide, is astonishing to me. And the fact that the court a court that is in other ways so much focused on parental rights, that they would not see this or even take the issue up is deeply troubling. The second thing I'll say on the equal protection issue about Scrimetti is that, it's not either or. I think, as Professor Blackman rightly points out, yes, it could be age discrimination, and that claim doesn't have much merit in my view, for the reasons he's pointed out. But it can be both, right? It's a floor wax and a dessert topping. That's a very, very old reference.
Gross.
There's an old Saturday Night Live parody commercial where Dan Aykroyd and Jane Curtin, that's how old it is.
Yeah.
They don't know that.
That's fine. That's fine. But anyway, the point was they were arguing over whether new shimmer is a dessert topping or a floor wax. And it turns out it's both. So this could be both age discrimination and sex discrimination. So Chief Justice Roberts saying, well, it's age, not sex, to me is, and some of the concurring justices didn't really buy it either, ignores the possibility that it could be both. And it is sex discrimination in any meaningful way because it uses sex as a classification. And in the anti-miscegenation case, Loving versus Virginia, the court said using the classification itself is what raises the question of a possible violation of equal protection, because it used race, even though Virginia tried to argue that, well, blacks and whites are being treated equally. Neither one can marry interracially. Well, you can't use the classification at all. That raises strict scrutiny. In this case, it uses sex as the basis for the classification. It should have justified intermediate scrutiny. And in my view, the law would have failed under that. But the bigger issue for the court is that they refuse to recognize it as sex discrimination. Okay. So that's Scrimeti. And we can talk more about it if you all have questions about it. The first case I'm going to talk about is, I think, a natural segue, and that's the Catholic Charities case. I'm sorry, not the Catholic Charities case. I'm going to talk about, actually, it's another one of your cases. So
Mahmoud.
Mahmoud. It's Mahmoud, but I'll talk about Catholic Charities.
Yeah.
Not as a natural segue. Wisconsin, this is a challenge to a Wisconsin law that exempted certain religious organizations, but not all, from paying unemployment compensation taxes. Under federal law, states are permitted to enact these religious exemptions if they choose, and Wisconsin did. To qualify under Wisconsin law, a nonprofit had to be operated primarily for religious purposes and be operated, supervised, controlled, or principally supported by a church or convention or association of churches. The Wisconsin Supreme Court said, we reject Catholic Charities' eligibility for this exemption. They have to pay unemployment compensation taxes because Catholic Charities, the Wisconsin Supreme Court said, was not operated for primarily religious purposes under the requirement of the statute, because they didn't engage in proselytization and they didn't limit their charitable services only to Catholics. And the Supreme Court unanimously, in a decision written by Justice Sotomayor, said, as the state Supreme Court has construed it, which they have to take as correct, because it's a question of state law, if that's your construction of your state law, it is a blatant violation of the First Amendment, because it tells some religions or religious organizations what they have to do and how they have to do it, and then they have to be organized in order to qualify for an exemption, and that treats some religious organizations better than others. And the court said you can't base eligibility for a government program, or in this case an exemption, based on inherently religious choices, whether to proselytize. If Catholic Charities decides not to proselytize, that's a religious choice that they're entitled to make, and they're being penalized for it. And the government can't dictate those sorts of choices, or whether they want to extend their services to more than people of their same religion, non-Catholics in this case. You can have, in neutral secular criteria, the state can, that may impact different religious organizations differently, but they can single out religions on a religious basis. And the court was unanimous on that, and in my view, all of them got it correct. And so much so that I almost wonder, what could they have been thinking at the Wisconsin Supreme Court to have just gone so far off course under almost any era of the Free Exercise Clause and the Establishment Clause, but certainly in this era. That was not, as I would put it, reading the room. Mm-hmm. They did not. The Wisconsin Supreme Court did not read the room, that is the U.S. Supreme Court, in any way that even bordered on reality. And so I think that decision was perfectly correct, although it's part of a pattern that I think is troubling in the court's religion clauses jurisprudence. In fact, I'm working on an article about that. But this one, I don't have any problem with.
Yeah, I filed an amicus brief in this group, and I have a group of Jewish scholars. And one of the problems also is it imposed a very evangelical approach to the law. Jews, we don't evangelize. We don't proselytize. We're not even allowed to. So basically, if this is the rule, Jewish charities could not even exist in Wisconsin because they would never be subject to this test. So it was helpful or not, I don't know. Something inside our brief, but it was there. The next case I want to talk about is Mahmoud v. Taylor, and Professor Marcus mentioned that a moment ago. And let's just start with the name, Mahmoud v. Taylor. This is not a Christian plaintiff. This is a not unusual case, but it's sort of an outlier case where you have a Muslim family bringing a religious liberty claim. This case arose from Montgomery County, Maryland, which is a very, very, very wealthy suburb of Washington, D.C. I think Justice Kavanaugh and the Chief Justice both live there. The school district adopted a policy that requires certain LGBTQ plus storybooks for elementary school education. And the express purpose of this was to disrupt thinking about sexuality and gender. Initially, parents were allowed to opt their kids out of this program. Now, I have young kids, and now I'm seeing how these opt-outs work. Okay. Believe it or not, a lot of parents opted their kids out. So much of those actually disruptive. They couldn't even have the class. Almost everyone was deciding not to go to these lessons. So they basically got rid of the opt-out. All right. A group of parents brought a challenge. And this wasn't, again, Christians. They were Muslims. They were Buddhists. Basically, every religion under their sun was objecting to this. The argument why, going back to Scrimeti, they said this law interfered with their ability to raise their kids in a religion of their choice. Specifically, let's say that a religion teaches their kids there's only two sexes, male and female, Adam and Eve. And they go to school saying, oh no, that's not true. There are all these other sexes, right? You have to learn about transgender and intersex, everything else. Okay. This was not exactly a substantive due process challenge, although it kind of was. This is one of the weird wrinkles of how law developed. Originally, before incorporation, the rights of parents to direct their kids' upbringing was actually substantive due process. But later, after the court incorporated the free exercise clause, they kind of shifted over to the free exercise clause. So Mahmoud is kind of substantive due process, but not really. It's really a free exercise case. And here the court split 6-3. This was another case where it was hard left-right. Justice Alito wrote the majority opinion. You have a dissenting opinion again by Justice Sotomayor. By the way it works is when you are in the dissent, the most senior judge gets to assign the dissent, who writes it. And Sotomayor gave herself the dissent in this case, and she gave the dissent to herself in the Scrimeti case. So when you're, for the longest time, Ginsburg was most senior member. Before that, Stevens was. When you're the most senior, you kind of get all the opinions for yourself to keep. The Alito opinion said that requiring parents to submit their kids to instructions poses a very real threat to undermining their religious beliefs. They said there's an objective danger to free exercise of religion. Now, lurking in the background, of course, is what are the rights of students and free speech in general. Students have, at a public university, sort of restricted free speech rights. You have some, but not a lot. You can't cause disruptions otherwise. But generally, you have to sit through instructions you don't like. But this creates basically a constitutional right to opt out of this sort of instruction. The dissent actually focused on the merits a lot, which they usually don't do. They said the books weren't actually quite as bad as the majority said. In fact, Justice Sotomayor basically said the majority misread and misinterpreted these books. They were about couples that loved each other and wanted to be happy, and they weren't really about indoctrination. The sort of upshot of this case, though, is what happens on the other side. Now, this was in a very deep blue county with conservative parents opting out. What happens if you're in Texas or Alabama or Mississippi and you have a conservative school board and the liberal kids want to opt out? We have, for example, in Texas, you have to have the 10 Commandments on the wall, right? Well, people say, I don't mean to follow the 10 Commandments. That interferes with my religion as well. So this case, in some regards, is very big for conservatives, but also might help liberals down the road. We'll see how that shakes out.
Yeah, I think that there's if we're going to have a public education system, the opt-out is don't send your kids to public schools. It's not you get to dictate what they will be exposed to. Living in a pluralistic society means you have to be exposed and taught that other people may have different views, may have different cultural assumptions or identities. And if we're going to I think the Supreme Court has taken us, or started us at least, down a road where people will be able to even further silo themselves from the society in which we live and say, well, I don't want my kids exposed to that. I'm going to send them to public schools, but I will get to dictate what they will learn, what materials teachers can use, what lessons, and that sort of approach, I think, is deeply dangerous to how public education in a pluralistic society works. And it is, as Professor Blackman points out, very much a be careful what you wish for, you might get it type of situation. Because these parents, and by the way, there were also Christian plaintiffs, although the named plaintiff was Muslim. If these parents can have their kids opt out of a lesson, what about a parent who, let's say, believes that that interracial marriage is wrong, and they don't want their kid to have a teacher who's in an interracial marriage? Can they opt out of that? Can they insist on who their teachers of their students will be, as well as the materials that that teacher will teach? I think it's a very dangerous road in terms of how society and how public education operate. And I think the court was very short-sighted in reaching that decision. Okay, the next case I'm going to talk about is Barnes versus Felix, also a unanimous opinion, written by Justice Kagan, although Justice Kavanaugh wrote a concurrence for himself, Thomas, and Justice Barrett. And this involved a police officer who was the respondent, Felix, who shot and killed a motorist during a traffic stop. Barnes's mother, since Barnes himself was killed, brought an excessive force claim against the police officer under the Fourth Amendment. The Fifth Circuit applied doctrine that it had essentially made up, in contrary to Supreme Court precedent, that said, in terms of judging the objective reasonableness of an officer's use of force, you look only at the moment of threat. And you can't look at any circumstances, the Fifth Circuit said, that went further back than 2 seconds from the time the use of force had been engaged in. And the court said that, no, we've never said that. And in fact, we said you have to look, in judging objective reasonableness, you have to look at all the circumstances. And sometimes what happened at the beginning of the encounter can inform the officer's reasonableness. And so the court did not resolve the case in terms of the ultimate outcome. It just said, we're remanding this back to the Fifth Circuit to ditch this moment of threat rule and apply our precedents in good faith. I think one of the most interesting things about this case was Kavanaugh's concurrence, as I said, which was joined by 4 justices, Thomas, Alito, Coney, Barrett, and Kavanaugh, who said, yeah, I agree that you have to take into account all the circumstances, not just the moment of threat, but the very strongly hinted or implied or pushed to the point, almost to the limits of what a concurrence should do, signal to the Fifth Circuit that, yeah, you ought to reject this claim on the merits. Once you do, we'll look at all the circumstances. What Justice Kavanaugh emphasized was, hey, traffic stops are really dangerous, and we have to put the most emphasis, even though we look at all the circumstances, on the moment of the threat. And that when you have evasion, which was what happened in this case, where where Felix had started to leave the scene of the stop, that evasion is a strong indication, Kavanaugh said, that the person poses a threat and might be about to commit a more serious crime, justifying the use of force, including, in this case, deadly force. So 4 justices certainly strongly signaled in Kavanaugh's concurrence that, yeah, the Fifth Circuit applied the wrong standard, but that doesn't mean that the police officer engaged in an excessive use of force. And if I'm a lower court judge, if I'm on the Court of Appeals, or if it gets remanded to the district court, I'm going to take that hint as one strongly indicating that even under all the circumstances, rather than just the moment of threat, this was not a use of excessive force.
Yeah, I don't have much to say about Crimpro. It's not a classic case. I'll leave those remarks there. But I'll do my third case. Let's see, I have transgender, I have story school books, and I have porn. So I can see where my mind is for these 3 cases. This involves pornography. Texas and other states have passed laws that limit the access of internet pornography to minors. And I'm asked, how do you do this? Well, there's lots of ways you can verify age. In the olden days, you'd have to upload a credit card, upload some sort of information about your driver's license. Now they have AI monitors that you can, they have this on phones. You can take a picture of yourself. You can do things to verify your age. Okay. A number of porn groups brought a lawsuit saying this violates the First Amendment. The thinking was that this will chill speech, that people who might otherwise want to see this pornography may not be willing to share their information about themselves on the internet and won't use it then. Okay. The Fifth Circuit upheld the law, and the Supreme Court more or less affirmed. The court held that this only incidentally burdened speech. The court split 6-3, with again Justice Thomas the majority here, and then Justice Kagan wrote the dissent. The challenge for this case is that there's a very old precedent saying that you can restrict adult material to minors. Okay, so back in the day, before you were all born, there were things called magazines. And it's true. And some of these magazines were called girly magazines or dirty magazines. And if you ever went to the store to buy them, they were kept in a plastic bag. And if you went to buy one of these magazines, you have to go to the clerk and show the clerk your ID. All right, that's how, same way if you buy tobacco or buy alcohol. So you have these precedents saying you can show the clerk at the store your ID, that's fine. How is this different? The argument went, well, here you're not just showing your ID to a clerk, you're uploading personal information to the internet. The court was not bothered by this. They said the state gets deference here because they are using appropriate means, the same way they would for buying alcohol, firearms, tobacco, and other sorts of things. Okay, the dissent would have applied strict scrutiny. And what's curious about the Kagan dissent, she didn't actually say the law is unconstitutional or constitutional. I think she even hinted that this law might survive strict scrutiny, which is unusual. Usually we teach that when laws reviewed with strict scrutiny, it's going to be declared invalid. But Kagan even hinted that maybe this law survives because there's a very compelling interest of keeping kids away from this harmful pornography. But she thought it was wrong to apply intermediate scrutiny. She applied strict scrutiny. I want to mention one other related case that probably affects you all is TikTok v. Garland. Who here has TikTok on their phone? Good. Okay, delete it. It's bad for you. But it's also illegal too. So under the law that was passed in the last administration, TikTok was to be banned starting in January 19th of 2025. On President Biden's last day in office, he basically said, well, we're not going to enforce this law for the next 24 hours. Trump, your problem. And then Trump came to office and said, we're not enforcing it either. Here we are 9 months later, the law has never been enforced. What's amazing is the Supreme Court upheld it. The court said that the ban on TikTok was not a regulation of speech. It was keeping a foreign adversary, China, out of your phones. Looking at all of you, right? So even though TikTok ban was upheld, the law never went into effect, and that's why you go look at your memes and other videos you're watching. Okay, I'm done.
Okay. Just a word about the Paxton case involving regulation of pornography. It's important to make the distinction between obscenity and pornography in this context, because everyone agreed that a lot of the material affected was lawful for adults to see, just harmful to minors. So no one was trying to access material that Texas had the right to regulate as it applied to adults, right? An adult had a constitutional right to access the material at issue here. But they did have the authority and the constitutional right to say it's harmful to minors, although not obscene. And one thing that I thought was interesting, it sort of reinforces the lesson of Barnes versus Felix, which is what's the right standard and how do you then, if you don't agree with the lower court standard, what do you do? And in Barnes, they said, we're going to remand this to apply the right standard because they got it wrong. In Paxton, the court agreed that the Fifth Circuit had gotten it wrong because the Fifth Circuit applied rational basis scrutiny. And the Supreme Court said, no, it should have been intermediate. Of course, the dissent, as Professor Blackman points out, said it should be strict, but the Supreme Court said it should be intermediate. One thing the court could have done in that context would have been to say, now that we've decided it's intermediate, we're going to remand for the Fifth Circuit to apply that standard first rather than us applying it on the fly without a lower court having first done that work. But the court didn't do that in this case, which I thought was interesting. The court said, okay, it should be intermediate scrutiny, and we're going to uphold the law under intermediate scrutiny, despite the burden that it places on adults who are, I think, fairly afraid and nervous and worried that if I put my information out there, it'll get hacked. And all of a sudden, my privacy will be will be compromised. And so people weren't willing to put their driver's license or passport on the internet. So that was the burden, I think. And the court said Texas, because of this important interest in protecting children from harmful material, can compel people to bear that burden to avoid the potential harm to children who would access the information. Okay. The last case we're going to talk about is FCC versus Consumers Research. Many, many, many years ago, Congress enacted a program to promote universal service, access to a means of communication services throughout the United States. Because a lot of times, especially in rural areas, people don't have the means to get, in the olden days, phone service, and now internet service in the modern era. To achieve this, in the same year I came here, in 1996, so you know it's a long time ago, Congress authorized the Federal Communications Commission to charge carriers, that is internet providers, phone companies, et cetera, that provide interstate telecommunication services to contribute to a fund that would pay to achieve, as much as possible, universal service for those who otherwise wouldn't be able to afford it. Rural school districts, for example, that wanted to be able to provide modern communications, internet access to their students to work in school, individuals as well. And the commission can use that money that it charges to these telecommunications carriers to subsidize universal service. A group of telecommunications companies challenged this because Congress had not set the rate of this tax, that it delegated that authority to the FCC based on a set of criteria that would guide the FCC's exercise of this discretion. And picking up on a now long-standing, but certainly also recent campaign to force Congress to be more precise in its delegations or not delegate certain authority at all, these communications carriers said, this violates the non-delegation doctrine. It is taking legislative power to set a tax and is giving it to a federal agency. And the hope, I think, on their part was the court would take this opportunity to reinvigorate the fairly moribund non-delegation doctrine and really force Congress to either not delegate authority at all, to exercise its authority itself, or at least provide very clear criteria to the agency to require them to not have too much discretion, because that violates the separation of powers. I think, in my mind, somewhat surprisingly, the court upheld this delegation, I believe 6-3, with a concurrence that I'll talk about in a second. And just to give you a sense of what the statute says, the statute, in terms of giving the FCC guidance, it says that the statute says that services shall be available at just, reasonable, and affordable rates. All regions of the nation should have access to service. Customers throughout the nation should have access to services that are reasonably comparable in quality, and carriers should make equitable and non-discriminatory contributions to service. Okay? Kavanaugh concurred, and I think the concurrence is, to me, the most interesting part of this case. He said he would take a different view if this was an independent agency rather than an executive agency, and we can talk about the nuances of how those differ. He said, he added a major caveat about the major questions doctrine, even though this was not a major questions doctrine case. And he said, the major questions canon has not been applied by this court to the national security or foreign policy context because it does not reflect ordinary congressional intent in those areas. So what Kavanaugh was signaling was, when we get into issues like immigration, tariffs, the president is we're going to give more deference to the president and not require as much precision from Congress in delegating authority, which is quite to me, the astonishing assertion, because in the lead up to this, in the major questions cases, the court has said anything that's a major question, if we think it's an important issue, the Congress has to give clear guidance to the executive branch. Otherwise, anything that is vague and ambiguous will be struck down as an impermissible delegation by Congress to the president. And I think you can expect Kavanaugh was laying down a marker there and saying, don't come at us with major questions doctrine when it comes to these issues of immigration and tariffs in particular, others as well. And to me, that's the interesting takeaway from the FCC case.
Did we finish at 1 or 1:10? What time did we finish?
110.
Okay, good. We have time. Yeah, I actually had a similar reaction to the Consumer Research case. In recent years, Justice Gorsuch has been the biggest opponent of the administrative state in the court. And he's been trying very hard to reinvigorate the non-delegation doctrine going back to the 1930s, trying very hard. And I think Kavanaugh basically signaled, I'm good, right? I'm okay with the major question doctrine. We'll apply it in some contexts, but not others. We don't need to find whether there's intelligible principle, because we can just say this question is really big, really major. We just won't find the power that Congress was given there to the executive. This was also one of the few cases that went 6-3 with the conservatives in dissent. So what we're seeing here, I think, is that Justice Barrett and Justice Kavanaugh are not going whole hog against the delegation doctrine. I think they're going to pull back. Well, Roberts, whatever. Right? These puppies. I don't mean to criticize the Chief Justice, but he knows what time it is. He's very much attuned to what the room temperature is, and he'll go along with the others are. I don't think he has strong thoughts here. He did join the Gundy dissent back in 2019. This is a case where Gorsuch said, let's look at non-delegation again. But then he had a free vote because it was an 8-member court. It didn't really matter.
And by the way, the dissenters were Gorsuch in this case, Thomas and Alito.
Yes,
just to be
clear. All right, let's pause here and let's have some time for questions, if that works for you. What questions we have? Yes, in the back.
I think, like, just bringing it back to your last point, would you agree that the court more split, not exactly on the 6-3 lines, but more rather like 3 liberal bloc, and then Kavanaugh, Barrett, Roberts, and then kind of like the 3 other conservatives? Do you kind of agree with that notion that that's kind of how the court?
I think I made that one up. I think I was the first person to write the 3-3 court. A lot of people have copied me on it, but I think I was the first one to write about it. I think that was right in 2021 or 2020 when I first wrote it. I'm not sure it's quite there anymore. I've seen Kavanaugh pivot to the right hard in the last year or two. He's not where he was 2 years ago. Kavanaugh used to have these very, empathetic concurrences, like, I feel really bad. I'm sorry, I'm really against you. I love the people. He doesn't do that anymore. And now he's joining the Thomas, Gorsuch, and Alito block a lot more. So to the extent there was a 3-3, I think Kavanaugh's breaking off. Also, Barrett, I've been probably her biggest critic on the right, if not biggest, maybe one of her biggest critics on the right. She seems to be firming up a bit. And I think if you look at her emergency docket rulings the last several months, she's with the conservatives more and more. In fact, there are cases where Barrett's with the conservatives and Roberts is in dissent. As for the Chief Justice, he's fluid. I don't think there's any solid principle there. I think he just sort of moves with the moment. And I think Roberts, again, wants to be in the majority. He doesn't want to be in dissent by himself. So he will go with the conservatives but keep them sort of in line. So we'll see what happens this term. Professor Marcus had mentioned the tariff case. That's actually a huge case with potential consequences with the separation of powers and the economy, right? If the court says no tariffs, I don't know what that does to our economy. Actually, I have no idea what that even would mean. So we'll see where they are. But on social issues, I do think the 3-3 line does go there. I think you're having Kavanaugh and Barrett are just more hesitant to go further. We'll see what just today there's a case we argue called Childs versus Salazar involving conversion therapy. We'll see what the court does there as well.
Yeah, I have a perhaps cynical, but I think accurate explanation for the movement of the court, and I think the court has what Professor Weidman calls firming up is hypocritical willingness to uphold anything Donald Trump does, whereas they struck down many things that President Biden did. And so, of course, they're firming up because they like what this administration's doing. They're on the emergency or shadow docket. They have upheld actions by the president that are directly contrary to long-standing Supreme Court precedent, Humphrey's executor. And as the dissenters in those cases have said, I think quite rightly, if we're going to overrule Humphrey's executor, we should do it in the normal course, not without reasoned opinions, not without full briefing, and effectively overruling Humphrey's executor allowing the firing without cause of a commission like the FTC, et cetera, officials is not the way we should be conducting our business. The court that was so eager to rein in excesses by Congress in terms of delegation or executive authority in the student loan case, for example, now doesn't find it important or to rein in a rampant executive at all. What's changed? The R next to Donald Trump name versus the D to Joseph Biden's name. Cynical, but
Yes,
oh
go ahead.
well.
I want to come back to Mahmood for a moment. Professor, you articulated that the remedy is not to allow an opt-out, it's to yank your kids out of public school, put them in private school. I don't think that necessarily gels, because then that's an economic barrier, and that disenfranchises a great vast majority of people who are in these public school systems because they don't have another option. Is the option instead to embolden your state boards of education to have greater control over particular curriculums and give that control through the legislative process instead of maybe making a big broad sweeping exemption from the court? Is that maybe more in line with what you consider more appropriate?
Well, I think, ultimately parents, I agree it's a barrier and it's a problem, but ultimately parents have to make a call, make a decision. Am I willing, if I want to go to the public schools, I go to the public schools. Or if I need to go to the public schools, I have to sacrifice some autonomy, and maybe my child will be exposed to things I don't believe. If, for example, in a biology class, or some sort of science class, the teacher in 8th grade or whatever it is teaches that evolution is the way the world has and life has evolved on planet Earth, and a parent objects to that because they believe in the biblical story of creation, and they want to say, I can opt out of science. You can't opt out of we have to give ultimately decision-making authority to government officials. If you don't like what the school board has done, vote in a new school board, but you can't dictate what will be learned in schools. That's what homeschooling is for, or that's what private schools are for. And if we're going to have a system of public education, there has to be a means for that education that curriculum to be created and dictated. Otherwise, everyone becomes an authority unto themselves, and I don't think it's the way it works. It's certainly not the way it worked in Scrimeti, where the parents were not their right to direct the upbringing of their children was not recognized by this court.
All right, so you mentioned legislative oversight. The problem here is the legislature was a school board, and Maryland's a deep blue state. So they're not going to have any sort of potential for Republican parents to win in Maryland. The bigger issue is whether there's actually a right at issue. Now in Scrimeti, the court ducked the substantive due process issue. But I think what they would have said, what the Sixth Circuit said, there's no right to direct this sort of treatment for your minors if the state deems it harmful. Right? The state deems these puberty blockers and hormones to be harmful to kids. I don't care who you are as a parent, you can't do things that are harmful to your kids. Conversely, you do have a religious liberty right to teach your children your faith. And when the state interferes with that religious belief, that's when the law must give an opt-out, and that's what the court said.
I just have to respond to that.
I know you do.
Except it does not in any way interfere with the parents' ability to raise their kid in whatever religious tradition they believe in, send them to whatever church or no church that they believe in. Oh my gosh, they will be exposed to a different perspective in schools. That's been happening for decades and centuries in this country. That parents have been saying, I can't believe what they're teaching my kid in schools, that's harmful to me, and that's the way it's always worked. And for a court that says it respects history and tradition, that is to me, Mahmoud ignores the history, tradition, and nature of public education in this country. Parents have to assert their views and trust that that they're raising their children right in their minds, and what they will be exposed to out in the rest of the world, that's always been an issue, a struggle for parents. There's nothing new about that. There's only the willingness to give parents a license to interfere with public education that's new.
All right, I'll let him have the last word on that one. What other questions we have? Yes, ma'am.
In cases, you talked about the reproductive, reproductive and gender affirming care case. What about in cases where, like what, I guess, constitutes gender affirming care in the cases where the child is born intersex? Such as, I mean, for example, if you have, complete androgen insensitivity syndrome, you are biologically, you appear as female, but, biologically you have, male gonads. The treatment for that is hormone therapy in order to prevent certain other diseases from forming, such as osteoporosis. In that case, I mean, typically it's best, it works better if it's, administered typically at the onset of puberty, but typically the onset of puberty, you're not an adult. In those cases, if you're looking to cure someone, what's the response of the government in that case?
I think it varies from state to state. Not all these state laws are identical. Some state laws have carve-outs, I think Kentucky is one of them, for the exact situation you're talking about. That for children who are intersex, they can receive treatment. But not all states have done that. And I don't think the court, I don't believe in Scrimeti the court reached that issue because it wasn't really presented. So I think there's still the opportunity there for an as-applied challenge where the parents of an intersex child might say, as applied to my situation, our family situation, this law is unconstitutional. I don't think the door is closed
Yeah.
for that kind of a challenge.
Yeah, I'm just looking. So the Tennessee law permits permits treatment to, I'm sorry. Procedures are permitted if the purpose is to treat a physical chemical abnormality present in a minor that is inconsistent with the normal development of human beings of the minor's sex, including abnormalities, So intersex is excluded. So that would be covered by the Tennessee law. Thank you. Yeah, maybe someone else. Go ahead.
Mahmood, so in your view, could a school board go too far? Like say the Westboro Baptist Church takes over a local school board. Could that go so far that you believe like, oh yeah, there should be an opt-out?
No, in my view, if you go into the public schools, and the Supreme Court has held this before, in a case called Island Trees versus Pico, that the school board gets to set the curriculum, and parents may not like it, some parts of it, but they don't get to pick and choose. It's not like a buffet. It's you order the dish, and yes, the school board can choose to give parents the ability to opt out of certain parts of the curriculum if they want to. Just like at a restaurant, you can order a dish and say, can you leave out the onions? But they don't have to. The restaurant can say, sorry, we can't prepare that dish without the onions. And if the school board, like the restaurant, doesn't want to make an exception or an opt-out, they should not be constitutionally required to do so, whether the objection is personal, philosophical, or religious. That's the nature of public education. So if I don't like what my school board is doing, I have other choices, but you don't get to pick and choose. That's my view.
All right, I think that's about it. Thank you all so much for your time.
Thank you very much.
Thank you.